When?
When? When do you want?
Today, your lordship, if it is possible, my lord.
Okay, all right.
I'm obliged, your lordship.
But at 2 o'clock.
My lord, your lordship.
May I please, my lord? Lordship, kindly allow me to mention item number 39.
Yes.
In this matter, I'm yet to receive instructions. So, your lordship, if 3 weeks time may kindly be granted, your lordship. I've informed the other side.
Mr. Angami, learned government advocate. For the state respondent with consent from the other side, press for listing the matter after 3 weeks, as he has not received any instruction
Lordship.
from the respondent authorities. Where allowed, recess and list the matter after 3 weeks.
Lordship, I have a similar prayer for item 40. It is the same petitioner counsel, your lordship.
Okay. Say.
I'm deeply obliged.
His lordship, I beg to mention item number 30. It's fixed for hearing today. However, I have some personal difficulties, my lord. So kindly grant me 1 week time, my lord.
Item 30.
Yes, my lord.
Mr. Your name, please?
Yes, Sophie, my lord.
As Sophie, learned counsel for the petitioner with consent from the other side, press for listing the matter after 1 week.
My lord.
1 week, as he has some personal difficulties today. Where allowed. Let's list the matter after 1 week.
Obliged, my lord. Obliged, my lord.
Should I back to mention item number 49?
Yes.
It's listed for mediation, lordship. This matter, Bennett.
It was referred to the mediation.
Yes. Good.
Whether report is received.
It's fixed on the 8th of September and the pleadings are yet to be completed. It's a contract matter. If it can be taken upon that fixed date, because mediation may not work.
On 8th of
8th of September.
September. Mr.
More Jamil lordship.
Moazamir, learned counsel for the petitioner with consent from the other side, press for listing the matter on 8th of September.
Yes.
Where allowed.
Obliged.
May I please, lordship? My lord, I beg to mention item number 3. My lord, here I'm yet to receive instruction from respondent number 6. So kindly allow me 3 weeks time, my lord.
Item number 3.
Yes, my lord.
You are appearing as
Respondent number 5.
CPSA.
No. State respondent. my lord.
State respondent.
5, 6, and
So, learned
4, 5, and 6, my lord. But 4 and 5, I filed
government
agreement, but
advocate
6
for
have yet
the
to receive.
respondent number 4, 5, and 6.
Yes, my lord.
With consent from the other side, press for listing the matter after
3 weeks, my lord.
3 weeks. Any objection?
Lordship.
The pair having not been opposed by Mr. Mauzami, learned counsel for the petitioner, stands allowed. Recess and list the matter after 3 weeks.
3 weeks, my lord. My lord, I have a similar prayer for item number 24. Here I'm yet to receive instruction.
Okay. Same order.
Much obliged.
Obliged.
Mr. Lordship. Lordship, I beg to mention item number 10. My lord, I've been instructed by the council for respondent number 5 to 7, since he is not feeling well. So this matter will be listed after 2 weeks, my lord.
Item number
Then, my lord.
10.
Yes, for the respondent number 5 to 7.
Mr. Your name, please?
C form
C form, learned counsel for the respondent number
5 to 7 Z.
5 to 7. With consent from the other side, press for listing the matter after
2 weeks, my lord.
after 2 weeks, as the learned counsel has not received any instruction. Any
I
objection?
will bring on behalf of the petitioner, on behalf of Mr. James. my lord.
Mr.
I have no objection.
Mr.
James Newman, for the petitioner.
James. Learned counsel appearing on behalf of the petitioner.
My lord.
Obliged.
Fair allowed. Yes.
My lord.
May I please, your lordship, I beg to mention item number 42. Here, your lordship may please do list this matter after 1 week to file the affidavit in reply filed by the state.
Sir, your name, please?
Lelam Chong Pim Chonger.
Learned counsel for the petitioner. submits that he may be granted 2 weeks time,
1 week.
1 week time
Yes.
to file a reply to the affidavit in opposition filed by the state respondent. Where allowed, recess and list the matter after 1 week.
Deeply obliged. Lordship, I may be pleased to mention item number 33. Here, your Lordship may please to fix this matter on 1st of September, that is coming Tuesday, since my senior has some personal difficulties.
Mr. Your name,
Lilam Chong P. Mchongor,
learned counsel appearing on behalf of Mr.
Ezimomi.
Learned counsel for the respondent or petitioner,
No, respondent number 3.
or respondent number 3. With consent from the other side, press for listing the matter on 1st of September. 1st of September.
Yes,
Fair
Lordship.
allowed.
No question. Deeply obliged.
Much obliged.
Lordship, I may be allowed to mention item number 28. Here, my senior, I'm appearing on behalf of my senior Lucino for respondent number 6. Here, she is indisposed, kindly list this matter after 2 weeks.
You are for the petitioner here or respondent?
For respondent number 6, appearing on behalf of my senior Lucino.
Mr. So learned counsel appearing on behalf of Mr. Luigino. Learned conducting counsel for the respondent number 6 with consent from the other side, press for listing the matter after
2 weeks,
after
Lordship.
2 weeks. As the conducting counsel for the respondent number 6 is indisposable, pair allowed, list the matter after
2 weeks.
2 weeks.
Deeply obliged, my lord.
Members, my lord, I beg to mention item 7. Lordship, if this may come up after 2 weeks, Lordship. Or Friday. Either Friday, if not possible, then after 2 weeks.
Okay, we'll try on Friday then.
Friday,
Yes,
Not
Mr.
Friday.
Pasiko Pote,
item 7.
learned counsel for the petitioner. With consent from the other side, press for listing the matter on Friday. Pair allowed.
Well, bless you.
List the matter on Friday.
May I please, your lordship, I beg to mention item number 12. Here pleadings are completed, so if this matter can be listed for admission hearing after a week, your lordship.
Okay. Heard, Mr. Walling, learned counsel for the petitioner, and madam, your name, please?
AIME, your lordship.
You are government
Yes,
advocate,
your lordship.
government advocate. For the state respondent, it is submitted at the bar that pleadings in this matter has been completed, and as such, the matter may be listed for admission hearing. Admission,
Yes, your lordship.
fair allowed, this is a list the matter for admission hearing after
After a week, your lordship.
a week.
Your lordship, I beg to mention item number 45. Your lordship, here I'm yet to file my affidavit. I'm yet to receive the pairwise comment, so kindly grant me 3 weeks' time.
Yes, any objection?
Objection.
Objection. Madam so and so, learned counsel, no, learned government advocate for the state respondent submits that she has not received any instruction. And she tries for granting her 3 weeks time to file counter affidavit. Where allowed, recess and list the matter after 3 weeks.
Your lordship, item number 46, on behalf of my colleague Livika, your lordship. Your lordship, this matter has been wrongly listed. It came up for motion only on 13th of August. So kindly let this matter come up after 4 weeks, your lordship, to receive necessary instructions.
So and so, learned counsel appearing on behalf of Mr. Livika, learned government advocate for the state respondent. Press for listing the matter after 4 weeks, as no instruction has been received from the state respondents. Where allowed, you inform the other side
Yes, your lordship, they are aware.
with consent from the other side. Okay, where allowed.
Much obliged, your lordship.
Members, Lordship, I beg to mention item 13. Lordship, here, there's an analogous matter that is WPC 240 of 2025, which is fixed on 1st of September. So I pray that this measure may be listed along with the WBC 240 on 1st of September.
Okay. On the pair being made by Mr. Wallen, learned conducting counsel for the petitioner, wishes to list this matter along with WPC number
240 of 2025.
240 of 2025 on 1st of September.
Lords.
Pair allowed.
Obliged.
Members, Lordship. Lordship, I beg to mention item number 31. On behalf of additional AG, Ms. Sogret. Lordship, we can list this matter after 2 weeks.
On behalf of
Additional AG, Ms. Sogret.
Ms. So learned counsel appearing on behalf of the learned additional lazy. Any objection?
I cannot object, she is not present, your lordship.
Okay. With consent from the other side, press for listing the matter after
2 weeks.
2 weeks. Pair allowed. Okay.
Lordship.
Lordship, I also like to mention item number 36. Here I need to receive the status regarding the regularizations of the petitioner. So Lordship, may kindly list this matter after 2 weeks.
Okay. On the pair being made by Ms. So learned government advocate for the state respondent. You inform the other side?
I could see the other parties.
But you inform the other side with consent from the other side. Press for listing the matter after 2 weeks.
No.
After 2 weeks. Pair allowed.
Lordship, item number 17. My affidavit is under preparation, so kindly run to it 75 my affidavit.
Okay. Same order. Here also you have no objection.
Your lordship,
Okay.
I wish they can file their affidavit a little sooner, my lord, because it has been going on for quite some time now.
Yes, Lordship. Recently I've received, so under preparation.
Okay. And that please, my lord.
Okay.
Lord, your lordship.
In place.
Your Lordship, item number 38. Here affidavit is yet to be filed, Your Lordship, so kindly grant me another 3 weeks to file my affidavit.
38. But 38 is tagged to it?
Yes, Your Lordship.
37.
I have filed my affidavit and 38 I'm yet to file.
Okay. Ms. So learned government advocate. Appearing for the state respondent. Price for listing the matter after
3 weeks, Your Lordship.
3 weeks, so as to enable her to file counter affidavit. Any objection?
No.
The pair having not been opposed by Mr. Walling, learned counsel for the petitioner, command stands allowed. This is at least this matter after 3 weeks.
Sure.
3 weeks.
Lordship,
Along with her WBC number,
62.
because it is tag matter,
Yes, Your Lordship.
along with WPC number 62 of 2026.
Okay.
Please, Your Lordship. Should I beg to mention items 19 and 20? What we hear, we have received the affidavit in opposition filed by the respondents. Kindly allow me 4 weeks time to file my affidavit in reply.
Item number
19 and 20.
19 and 20, but these two items are tagged with item number 17 and 18.
Okay, we will be filing our affidavit in reply to the affidavit in opposition.
Okay, Mr. Your name, please?
Nomos on behalf of my senior Alam counsel for the petitioner.
Learned counsel. Appearing on behalf of Mr. Alam Wapang Au, learned conducting counsel for the petitioner, submits that the conducting counsel has received the affidavit in opposition and some time may be granted to file reply to the counter affidavit filed by the state respondent. Pair allowed, list the matter after
4 weeks.
4 weeks.
Please, Lordship. Yeah, please, Lordship. I'd like to mention item 11. Here, we have received the affidavit in opposition filed by the state respondent. So can you grant us 3 weeks time to file the reply?
Your name?
Odin Jinjabir.
Learned counsel for the petitioner submits that he has received a counter affidavit filed by the state respondent and he may be granted how many weeks?
3 weeks time.
3 weeks time to file reply to the counter affidavit filed by the state respondent. Pair allowed.
Like to
Now, this Lordship, Lordship, I beg to mention item number 14, Lordship. Here, Lordship, the learned Advocate General, Lordship, he has finalized the affidavit, Lordship, and it has been sent to the consent department for attestation, Lordship. So we'll be filing the affidavit during the course of the day today, Lordship.
You inform the other side.
I will inform them, Lordship.
Okay, Ms. Song, learned counsel, no, learned government advocate submits that the state respondent will file their counter affidavit during the course of the day. And she prays for listing the matter after
3 weeks.
After?
Lordship, I will be filing today, Lordship.
no, that's all right. When we list the matter?
After 3 weeks, Lordship.
3 weeks.
Yes, Lordship.
Okay, after 3 weeks.
Lordship, I also beg to mention item 18, Lordship. I pray that this matter may be listed after 2 weeks.
Okay, same order, but you inform the other side.
Yes.
Any objection?
I'm for a petitioner.
You have no objection. Ms. Song, learned government advocate, with consent from the other side, press for listing the matter after 2 weeks.
2 weeks, Lordship.
After 2 weeks, parallel. Okay.
Lordship, I also beg to mention item 25, Lordship. I pray that, Lordship, I'm yet to file it. So if 3 weeks time will be granted to me, Lordship.
No,
3 weeks time.
3 weeks time, Lordship.
Any objection?
no objection.
Allowed.
Lordship, I have similar prayer for item 45, 43, sorry, Lordship.
You inform the other side?
I will inform the Lordship.
Okay. After?
After 3 weeks, Lordship.
After 3 weeks.
Lordship. Much obliged, Lordship.
Mm.
Thank you, Sir Lordship. I beg to mention item number 4 on behalf of the leading counsel, Lordship, the leading counsel is disposed to continue this matter be fixed on 10 of September.
You inform the others.
My lord, I object for the petitioners. At least it may be recorded that no further adjournments, my lord. This is the second time without
Heard,
And-
Mr. Your name?
Akash Singh, my lord.
Learned counsel for the petitioner. And Miss, your name?
Rebecca
Rebecca. Learned counsel appearing on behalf of
Laknipong,
learned conducting counsel for the respondent.
correspondent number 2,
Respondent number 2 and press for listing the matter after
fixed on 10th of September.
10th of September, on 10th of September.
Interim to continue.
Pair allowed. It is however clarified that no further adjournment will be granted to file the
Great.
counter affidavit. Interim order passed earlier shall continue. Okay.
Much obliged.
May I please, Lordship? Lordship, I'd like to mention item 23, Lordship.
Item number
23, Lordship.
23.
Lordship, here, I'm here to file my counter affidavit, so Lordship, kindly grant it this time.
You are for the respondent number
2 and 3, Lordship.
2 and 3. Your name?
Mr. Kacheshi, Lordship.
Learned counsel appearing for the respondent number 2 and 3 with consent from the other side, press for listing the matter after
3 weeks, Lordship.
3 weeks so as to enable him to file counter affidavit. Pair allowed.
Obliged, Lordship.
Your Lordship, I beg to mention item number 21. Your Lordship, I'm for the respondent number 4. Kindly grant me 2 weeks time to file my affidavit in opposition.
Miss, your name?
Applicant,
Learned counsel for the respondent number 4 with consent from the other side, press for listing the matter after
2 weeks. Your Lordship.
2 weeks so as to enable her to file the counter affidavit. Pair allowed.
Much obliged.
Your Lordship, I beg to mention item number 35. I'm mentioning on behalf of the opposite counsel. They are unable to join owing to poor intellect connectivity. On the last occasion, the opposite counsel sought for time to receive some additional data, but they still haven't received those. So they are seeking for further time of 4 weeks.
You are for the respondents,
Petitioner,
petitioner. Miss, your name?
Chow Mong Yaden,
Learned counsel appearing on behalf of,
petitioner.
your name is there in the
Yes,
learned counsel for the petitioner with consent from the other side, press for listing the matter after
4 weeks.
after 4 weeks. Any objection? Pair allowed. Press shall list the matter after 4 weeks.
This your lordship, I beg to mention item number 8, your lordship. If 2 weeks time will be given for us, so that we will file our affidavit in reply to lordship.
You are for the petitioner.
Yes,
Miss, your name,
Vienna.
learned counsel for the petitioner. Submits that she has received a counter affidavit filed by the state respondent and she may be granted 3 weeks time.
2 weeks.
2 weeks time to file counter affidavit. No, to file a reply to the counter affidavit. Where allowed,
I'm for respondent number 3 to 6. Fine.
Mr. So and so for the respondent number 3.
3 to 6.
3 to 6. Okay.
Much better.
Please, your lordship, I beg to mention item number 41. The parties are not willing to participate for mediation.
Pardon?
The parties are not willing to participate for mediation.
Not willing to participate in mediation.
Yes.
Okay. Yes.
My lord, I'm for the petitioner here. So, my lord, here I'm challenging the appointment of the respondent number 4.
Mm.
And I would like to go for regular hearing.
Mm.
Yes.
No, the matter was earlier referred to the mediation.
No, this matter was listed for referral to special mediation drive. Today's cost list.
Today.
Yes.
Okay. Heard, Mr.
Elika Sesangda, my lord.
Learned counsel for the petitioner and Madam
Menashina for respondent, private respondent number 4.
private respondent number 4. Learned counsel for the private respondent number 4 submits that the parties are not interested to settle the matter in mediation, and as such, the matter may be listed for admission.
Yes. We are to file a counter.
Yes, ma'am.
And they have already filed counter affidavit.
We are yet to file.
Yet to file.
Yes. 3 weeks time may be granted.
And she prays for granting.
My
her
lord,
3 weeks.
let it be 2 weeks. There's an urgency involved in this matter.
Prays for granting 3 weeks time. However, 2 weeks time is granted to the learned, no, to the respondent number 4 to file the counter affidavit. 2 weeks.
Much
Obliged.
obliged.
Basis list the matter after 2 weeks.
May I please your lordship?
That is for legal.
Hmm?
That is for legal.
Which one? Okay. Okay. Yes.
May I please your lordship? I beg to mention item number 48. This matter is also being listed in the mediation lordship. However, the parties is not willing to
No,
go for the
madam,
mediation.
item number 48 under the column orders.
Lordship, but in the heading of the cost list, it
No,
is
no, no,
mentioned
no.
for referral.
No, this is under different heading, under the heading order.
Lordship. May please, lordship.
Yes.
I'm for the petitioner. Recently, an alia was filed for implement as well as amendment of the petition, and it was listed last week. So after 1 week, it was supposed to be listed. However, for mediation drive, it was listed again today. So we are yet to amend the writ petition.
No, this is, you see this. Only admission matters are listed for referral to the special mediation drive, not the orders, not the cases listed under the orders column.
Lordship. Lord, in that case, kindly grant 1 week time. 1 week, lordship.
On the appeal being made by learned counsel for the petitioner, having not been opposed by the learned counsel for the respondents, recess shall list this matter after 1 week.
1 week, lordship. Obliged, lordship.
May I please, your lordship?
Okay, here pleadings are completed. In this matter, pleadings are completed?
No, not yet.
Not yet.
Lordship.
Okay. So it will again come under order column.
Yes, for implement.
No, under order column.
Yes, yes.
Yes, this is
For
again list
the
the
matter.
matter under order column. Okay. Okay.
May I please, Your Lordship? I beg to mention item number 22. Our affidavit is ready and we have sent for vetting, so kindly allow me a week time to file my affidavit in opposition, Lordship.
Item number 22.
Yes, Lordship.
So and so learned government advocate.
Lordship, I also yet to find my affidavit, so I pray for 3 weeks time, Lordship.
You are praying for?
Respondent number 4,
No, no.
Lordship, 80.
You are praying for? How
My,
many weeks?
1 week, Lordship.
1 week.
Yes.
And Mr. Angami, you need 2 weeks.
3 weeks, Lordship.
3 weeks. Ms. So learned government advocate. For the respondent number?
4.
4. Press for granting her 1 week time to file the counter affidavit, and Mr. Angami also press for granting him 3 weeks time to file counter affidavit. And the pair having not been opposed by learned counsel for the petitioner stands allowed, recess and list the matter after 3 weeks.
Bless you.
3 weeks.
May it please your Lordship. Lordship, I beg to mention items 15 and 16, Lordship. Lordship, here I'm here to file my reply to the opposition, so kindly grant me 2 more weeks to file my reply, Lordship.
Miss, your name?
Mika Aiche, your Lordship.
Learned counsel appearing for the petitioner submits that she has yet to file. She has not yet filed a reply to the counter affidavit filed by the state respondent, and she pressed for granting how many weeks? 3 weeks.
3 weeks, Lordship.
3 weeks.
Lordship.
3 weeks. Parallel. Recess and list these 2 matters after 3 weeks.
Much obliged, Lordship. Lordship, I also beg to mention item 44, Lordship. Lordship, here the matter has been referred to the mediation and the parties here are ready for mediation, so.
Parties are ready to?
Yes, for mediation, Lordship.
Ready for mediation?
Yes, Lordship.
Okay. Heart, Miss, your name?
Mika Aiche, Lordship.
Learned counsel for the petitioner, and Mr. Learned government advocate for the state respondent. The learned counsel for the petitioner submits that the parties are interested to settle the matter in the mediation, and as such, the matter may be referred to the mediation. Accordingly, this matter is then referred to the Gauhati High Court, Kohima Bench Mediation Center. Recessal list this matter before the mediator, Gauhati High Court Mediation Center, Gauhati High Court, Kohima Bench Mediation Center. So do we fix a date here for appearance of the parties before the mediator?
Yes, Lordship.
When?
Next week, Lordship. If
Suggest the date.
uh, 8th of September, Lordship.
8th of September. 8th of September. After the mediation, the mediator shall file a report before this court. Okay.
Much obliged, Lordship.
For motion, item number 32 from the supplementary cost list.
Wait, please, Lordship.
Yes.
Lordship, the respondents number 1 to 4, they have occupied the petitioner's land in the year 1960. So it's more than 6 decades now. They have occupied without any due process of law. They are, in other words, they are in illegal occupation of the petitioner's land. Now, in the year 1960, they occupied land measuring 76.26 acres of land. Now, subsequently, in the year 1978, an interim agreement was executed between the petitioner and the respondents, that is the Assam Rifles, from respondent number 1 to 4, in the presence of the Deputy Commissioner Mond, since it falls within the jurisdiction of Mond district. So the agreement was to the effect that a land measuring 50 acres of land will be acquired under due process of law and compensation to be paid. So in terms of the agreement, acquisition has been done, compensation already paid. Where, however, Lordship, the remaining 26%, 26 acres of land is yet to be occupied, yet to be acquired by the Assam Rifles. So my prayer is to issue a direction to acquire the land in terms of the law. So there is also a statute in the state of Nagaland for acquisition of land. There is also 1894 Act. So the state can acquire the land and hand it over to the Assam Rifles if they intend to
No,
continue
if
occupying.
it is not required for them, why should they acquire the same?
They are already occupying it since 1960, which is illegal occupation. So without paying a compensation, they're continuing to occupy the land.
If you have signed the agreement between you and the Assam Rifle,
Yes.
but why
it
don't
was
you
only-
oppose at that time that you acquire the entire land or vacate the same?
Because
You have agreed for acquiring of 50 acres, and you remain silent for remaining 26.42.
Our intention and our request to the responding authorities was to acquire the entire land. But what they have expressed is that they will acquire the 50 in the initial stage. After that, the remaining will be acquired. It is an admitted position that they are in still occupation of the entire plot of land. Other similarly situated cases also pending before the Sonoma court. And they have already filed their affidavit stating that yes, they intend to continue to occupy the land. Whereas the only provisions under the statutes are yet to be fulfilled.
Yes. You oppose CGC?
My lord.
Yes.
May I please, Lordship, my lord, I'll be accepting notice on behalf of respondent 5, 6, and 7, my lord.
Okay.
State respondent.
Heard Mr. Moazomid, learned counsel for the petition. Mr. So learned counsel for the respondent. Number 1, 2, 3, and 4. And Mr. So learned government advocate for the respondent number 5, 6, and 7. In this petition under Article 226 of the Constitution of India, the petitioner has rightful issuing direction to the respondents to initiate the process of lawful acquisition of the petitioner's land measuring 26.42 acre in accordance with the applicable statutory laws, government notification, office memorandum, and other statutory provision governing acquisition. And also to issue direction to the respondent authorities for payment of premium equivalent to the cost of compensation as per the current market price within a period of 3 months. And further to direct the respondent authorities to pay rightful land rent with arrear from the date of occupation till the date of acquisition with interest within a period of 3 months. Mr. Zamir, learned counsel for the petitioner, submits that sometimes in the year 1960, the Assam Rifle has illegally occupied a plot of land measuring 76.42 acres situated at Naginimara under Mon district, wherein the battalion key location plan was established by the Assam Rifle without due process of law. Mr. Zamir further submits that in the year 1978, an agreement between the parties were executed wherein the Assam Rifle has initiated the process of acquisition of 50-acre land out of total occupied area of 76.42 acres. 42 acres, and he also submits that while the petitioners have raised objection for non-acquisition of the remaining 26.42 acres of land, then the respondent authorities stated that they will acquire the same subsequently. Mr. Zomir further submits that the petitioners are aggrieved for non-acquisition of the remaining 26.40 acres of land by the respondent authorities, and no rent has also been given to the petitioner herein. And as such, the petitioners approach this court by filing the present petition seeking the relief as aforesaid. The submission of Mr. Zomir, learned counsel for the petitioner, needs further consideration, and this notice be issued to the respondents returnable after 4 weeks. However, no formal notice is required to be issued since Mr. So-and-so, learned counsel, entered appearance for the respondent number 124 and Mr. So-and-so for the respondent number 5, 6, and 7. However, requisite extra copy of the petition be furnished to them during the course of the day. Rest is list the matter after 4 weeks. In the meantime, the respondent authorities shall obtain necessary instruction.
For orders, item number 26.
May it please your lordship.
Yes.
Your lordship, as per the office note dated 29/07/2026, a notice has been served upon respondent number 5. However, service report awaited. Therefore, your lordship, if you may allow us to serve notice to respondent number 5 by the way of Dusty.
Hard miss.
Need to withdraw.
Learned counsel for the petitioner and madam for the respondent number.
Or 1 to 24, lordship.
Respondent number
1 to 4.
1 to 4. 1 to 4. The learned counsel for the petitioner submits that she may be allowed to effect service upon the respondent number 5 through Dusty mode. Where allowed? Step be taken within a period of 2 working days from today. And after effecting service upon respondent number 5 by Dusty mode, the petitioner shall file an affidavit before this court. Rest is the matter after
2 weeks, your
2
lordship.
weeks.
Pleasure, your judge.
For admission, item number 1.
My blessed lordship, I received my instruction from the DC mode and my affidavit is under preparation, so kindly list this matter after 2 weeks.
Okay. Hard Mr. Fosiko Hotel, learned counsel for the petitioner. And Miss, your name?
Kitchen.
Learned counsel for the respondent number 1 to respondent number
1 to 5, lordship.
1 to 5, and you?
Ascendee Chamber for respondent number 4.
Respondent number 4. 4. The learned counsel appearing for the respondent number 1, 2, 3, and 5 submits that she has received instruction and she may be granted. How many weeks?
2 weeks, lordship.
2 weeks to file counter affidavit. Pair allowed, list the matter after 2 weeks.
Item number 2.
May it please lordship, I for the petitioner. Here the pleadings are completed. I pray the matter be set for hearing after 2 weeks.
Mr. Parkin Sabo, learned counsel for the petitioner, and Mr.
To Shitamjin for for respondent 9, lordship.
Respondent number 9, and Madam Song for respondent number
1 to 7, lordship. 1 to 7.
1 to 7.
Lordship.
1 to 7. Learned counsel for the petitioner submits that in this matter, pleadings are completed and the matter may be listed for admission. Where allowed, justice shall list the matter after
2 weeks.
For admission.
Reply.
Item number 5.
Your Lordship, I'm for respondent number 3 and 4.
Respondent number
Uh,
3 and 4.
3 and 4.
Petitioner is absent.
Yes, Your Lordship.
None appears for the petitioner on call. How about Mr. Your name?
Peter Rana.
Learned counsel for the respondent number 3 and 4.
Yes, Lordship.
3 and 4. And Mr. Angami for
1, 2, 5, and 6, Lordship.
1, 2, 5, and 6.
Your Lordship, I want to give submission with regard to them. We have filed our affidavit in opposition on 4th December 2025. And the petitioner have been seeking time till that. So this is my humble submission that kindly let this be the last opportunity for them to reply to the affidavit in opposition.
But they are absent today.
Yes, Your Lordship.
Learned counsel for the respondent number so and so submits that the petitioners have been taking adjournments for filing reply to the counter affidavit. And as such, last opportunity may be granted to them to file their reply. But the petitioner remain unrepresented today. In that view of the matter, no effective order could be passed today. And accordingly, it is provided that justice shall list the matter after 1 week. In the event of subsequent non-representation of the petitioner, appropriate order shall follow.
Much obliged.
Lordship, similar order may be passed in item number 6. Same parties.
Okay.
Yes.
Item number 9.
May I please, Your Lordship. Your Lordship, here the petitioner is challenging the appointment order of the respondent number 5, Lordship. Appointment order dated 4/7/2025. Lordship, here the petitioner is one of the landowner. The petitioner is one of the real and genuine owner of the affected land, which was acquired for the pavement of road during the establishment of Government Higher Secondary School at Wukan, Nagaland. Now, my lord, accordingly, the village council, my lord, may kindly come to Annexure 1, that is at page 10. Lordship, page 10, Lordship, Annexure 1. Lordship, accordingly, the village council, office of the head GP had given to whom it may concern that the petitioner is one of the real engineer landowner. Now, Lordship, at the time of acquiring the land for the establishment of the school for pavement of roads, wood, the petitioner was assured that a quid for post will be provided as in when vacancy arise. Now, my lord may kindly come to Annexure 2, that is at page 11, Lordship. This is the sketch map, Lordship. Your Lordship, in the left side, Lordship, it is written that the largest acquired land for Government Higher Secondary belongs to Udayus clan. Hence, the manual post grade 4 should be given to the landowner. Now, my lord, on being learned about the vacant post, the petitioner had made an application through proper journal, which has been annexed in my Annexure 3, that is at page 12. By obtaining the required documents through the District Education Officer Wuka. Now, my lord, accordingly, the same has been forwarded to the Principal Director, that is at page 15, by the Principal Government Higher Secondary School. Now, my lord, well, the petition was hoping for a positive response. The respondent number 5 was appointed by order dated 4th July, that is at page 19 clause A. That is the type copy, Lordship. Yes. The respondent number 5 was appointed. Lordship may kindly come to annexure 5, that is page 20. Yes, Lordship. It's serial number 1, Lordship. Name of the applicant Shuri so and so. That is the respondent number 5, Lordship. In the remarks, it is mentioned here that it was through a higher up authority, Lordship. Now, Lordship, the petitioner is being aggrieved that without conducting any sort of examination or interview, the respondent number 5 has been appointed, Lordship, without considering the appointment on the basis of land ownership. Hence, the petitioner is approaching this honorable court, Lordship. Yes, Lordship, in regard to my submission, I would also like to give one decision passed by this honorable court, Lordship. Which was passed in WPC 115 of 2019. My lord may kindly come to relevant para, that is at para number 10, page number 10, Lordship.
Yes.
Yes, Lordship, the relevant para is from 10, 11 to 13, Lordship. Lordship, I may be allowed to read.
Not necessary.
Not sure. That is my own submission, Lordship.
Okay. Yes, for the respondent number 5.
Lordship, insofar as the contention over the ownership of that approach road is concerned, since the competent authority is the state that
Yes.
since the competent authority is that of the concerned department and the state, because it is their duty to, they have done all the verification as to whether the contention raised by the petitioner that is accurate, that is genuine or not. So I will not be touching on this because in the counter affidavit taken by the learned government council, everything has been already mentioned. But be that as it may, I am on that point as well. Insofar as that plot of land, that approach road leading to that government high secondary school, Sungro, where the petitioner is contending that he should be, that aspect is already taken care of by the concerned department. The learned government advocate has already pressed those points in his counter affidavit. So I'm sticking to the bit as it may. Insofar as the appointment is concerned, private respondent number 5. Private respondent number 5 has submitted an application on knowing that there is a vacancy of that MDS, the post of peon. Subsequently, the person who was holding that was promoted as daftari. And on knowing that he also, since he is also an indigenous inhabitant of that particular area, he is also a tribal. So he had also submitted an application to the concerned department. So the concerned department, in all its wisdom, the department had undertaken all the necessary procedural works, and the administrative approval of the department was taken into consideration on 18th 6 2025, Lordship. And upon the administrative approval of this respondent five for the appointment of this MTS Pune, the appointment order was issued by the respondent number 3 on the 4th of July 2025. And that is how he has been appointed, Lordship, to the post of MDS, which was lying vacant. This is my brief submission, Lordship.
So you have not faced any interview conducted by the.
So far as that aspect is concerned, no, your Lordship, on the basis on knowing that there is a vacancy in the particular post, so I had applied for that post for an application, but no such interview was there.
And no advertisement was also published.
No advertisement so far as this post was concerned, Your Honor.
But there is one office memorandum of the government. How to fill up the vacancies of grade 3, grade 4.
That is
there. So whether any relaxation is provided in that office memorandum in respect of the indigenous inhabitant?
Insofar as that memorandum is concerned, Lordship, in my case, as far as that aspect is concerned, yes, respondent number 5, as I've already stated, on knowing that there is a vacancy, he has moved an application to the concerned department, and then the department they moved the process.
No. My question is whether any exception is carved out in the office memorandum in respect of the indigenous inhabitant.
Your Honor, in this matter, and so far as the particular memorandum is concerned, that doesn't touches this particular
issue.
Yeah.
Okay.
It is to submit, Lordship, that he is also indigenous inhabitant and Gauhati tribe by Naga tribe. So that's what I'm submitting, Lordship.
Yes, for the state respondent.
Yes, may I please, Your Lordship. Your Lordship, the issue of land appointment on land ownership basis has been laid to rest by this notification dated 5th March 2018, which you will find in my affidavit in opposition, page 8. Affidavit in opposition on behalf of respondents number 1 to 4. Page 8, typed copy at page 9, I'm not sure.
Yes.
Yes, Your Lordship. If I may take to page 10, type copy page 10. As far as this particular case is concerned, this clause should cover it, Your Lordship. May I read, Your Lordship?
Page number 10.
10.
Okay.
Clause 3B.
3B. Okay.
If there is any claim of providing employment as a result of oral agreement, the department concerned shall refer the matter to the Deputy Commissioner of the district concerned, who shall examine such claim carefully, including whether any employment or any other facility, including contract or supply order, has been given in the past. Written statement from the witnesses, that is the government officials of the concerned department and the district administration and village functionaries present at the time of such oral agreement, should be taken by the Deputy Commissioner. The recommendation of the Deputy Commissioner should be referred with relevant documents to the Department of Law Revenue for advice in such cases by the department concerned. Here, Lordship, since there's no written agreement as such between the landowners and the government. This and they're claiming on this should cover it. So in person to this, Your Lordship, if I may take you to page 2. The department had conducted the verification in person to this office notification, Your Lordship. Relevant, yes. Page 2, para 4 of my affidavit.
Yes.
Yes. If I may take you to the next page, page 3, and I'll start from the next para, Your Lordship.
Yes.
That by letter dated such and such, the DC Walker forwarded the verification report as received from the office of the ADC Sanis to the department of the answering deponent. That the ADC Sanis in its report stated inter alia that there were 2 approach roads leading to Government High School, Songro. One road from the east and another from the west. That the approach road that leads to Government High School, Songro from the east belongs to the Audio clan and not any individual. Now, this road, which comes from the east, the writ petitioner, belongs to this Audio clan. That with regards to the claim of the petitioner that there was a verbal assurance by the department government that grade 4 employment would be provided in lieu of the land acquired for making the road, the elder brother of the petitioner who was present during the time of the verification, Sri Janbemo Odio, who was present at the meeting, when asked, was not able to substantiate his claim of the verbal assurance with any evidence except for producing a letter dated nil addressed to the Director of School Education requesting inter alia that they be considered as landowners of the said school. If I may take you to page 22, Your Lordship. This is the letter that, yes. This is a document that they had provided during the verification, Your Lordship. May I read, Your Lordship?
Yes.
Yes, subject affidavit. Sir, with reference to the subject cited above, we have the honor to state that the present school building of Government High School Songro of Woka District touches some plot of land belonging to our clan, the Odios, and we have decided to give our land to the Educational Department, Nagaland. If the government requires more land for construction of hostels, staff quarters, etc. in future, we therefore earnestly request you to kindly look into the aforesaid matter and consider us as landowners, the said school. For this kind, we shall ever remain grateful to you. This was the only document that the brother had brought before during the verification, Your Lordship. And thereafter, that on further deliberation, it was verified that none of the immediate family members of the petitioner had availed the benefit of employment under the said establishment. That one Sri Ikimo Odio, belonging to the Odio clan, had been appointed and is personally serving as Dafshri under the said establishment. However, no recourse could be traced with regard to the ground of his employment, on how he was employed. Whether he was employed on land ownership basis or not, that could not be, no recourse could be found on that matter. But he also belonged to Odio clan, and this person and the family of the instant petitioner, their plot of land belonged to the same plot of land that is the road connecting from the east. There's a common plot of land. The one who was already availed employment and the family of the petitioner. They have a common plot of land which belongs not an individual, but it belongs to the Odio clan. So from that Odio clan, someone has already been appointed. That has been established, Your Lordship. And if I may take you to the next page, page 4.
Page
4.
Yes.
It is respectfully submitted that Sri Ikimo Odio's paternal uncle and who's the grandfather of the petitioner are both signatories to the aforementioned letter dated nil, which was placed by the petitioner's brother before the authorities. Therefore, it is clear that both Ikimo Odio, the person already employed under the said establishment, and the writ petitioner have a common plot of land, clan land. the approach road leading to the government high school from the east. Then after the ADC Sanis conducted the verification, the office received a document dated such and such from the Audio clan, the affected landowners of the establishment of the government high school, stating that the writ petitioner is a bona fide member of the Audio clan and that he is the grandson of Kumu Audio, who was one of the signatories of the application dated such and such. They further stated that a verbal agreement had been made between the affected landowners and the headmaster of the government high school. They have submitted a letter saying that there was a verbal agreement between the clan and the headmaster, the then headmaster of the school. Your Lordship, it is respectfully submitted that any agreement made with an unauthorized official is not valid, Your Lordship. As such, a headmaster does not have the authority to enter into such an agreement on behalf of the government of Nagaland. Section 12 of the Nagaland Rules of Executive Business 2020 categorically states the list of officers who can sign orders and instruments on behalf of the government, Your Lordship. I have annexed yes, Annexure 8, page 24, Your Lordship. Page 25.
So the stand of the government is that
Yes.
the respondent number 5 is also one of the landowner.
Respondent 5, no, no, Your Lordship, not respondent 5. Our
Private
stand is
respondent
that
number
the petitioners, the Audio clan, who belongs to Audio clan, since the land that they claim is not individually owned by them. It is owned by their clan. So the stand of the government is that someone from that clan has already availed the benefit. So the petitioner cannot be accorded the employment on land ownership basis again.
And whether you
Second
have
time.
furnished any of the document in support of that contention?
Yes, this is the verification report, Your Lordship, that has been verified in the verification report.
Page number
Page number 17.
of your affidavit?
Yes, Your Lordship. This is the verification report of the conducted by the
Where it is stated that another person has already availed that benefit?
Yes. Page 18, clause 6. On the petitioner's claim that no person from their family have been given employment till date, it was verified that none of the immediate family members of the petitioner have been given employment. Yes. However, one individual, namely Ikimbo Audio, belonging to the Audio clan, is presently serving as Daftri at GHS, Government High School.
No, whether this ground is sufficient without there being any supporting document? Whereas it is clearly stated that no record available regarding ground of appointment.
Yes. Records are not available to how, on what.
So
basis it
how
was
can
appointed.
we ascertain that he was appointed on land ownership basis?
Sure, Your Lordship. That is a sufficient. And furthermore, Your Lordship, for the petitioner to claim, assert his claim on land ownership basis, he has to prove that, he has to establish that there was a verbal agreement between the government, the then government, and the petitioners. However, that was not established during the verification. And it has been duly noted here, Your Lordship, on page 18, clause 6. If we continue, Your Lordship. May I read, Your Lordship?
Yes.
It was further established that Sir Shri Ikimo Audio, incumbent Daftri, the father's brother, who is one of the signatories of the letter, also grandfather of the petitioner, Wen Bentang, who is, okay, Your Lordship, I'll go to the last para, Your Lordship. As such, both Ikimo Audio, who was appointed, and Wen Bentang, who is the petitioner, have a common plot of land leading to the government high school Songro, and also are from the same clan who have donated a plot of land for construction and the road leading to the GHS. And if we come to page 5 here, para 5, Your Lordship, the first para of page 18.
Yes.
On the petitioner's claim that there was a verbal agreement that in lieu of the said land donated, members of his family would be provided employment. Elder brother of Ren Bentang, that is the petitioner, elder brother of the petitioner, who was present in the meeting, was asked to substantiate on the verbal agreement as filed in the petition. However, the brother could not present any tangible evidence other than producing a letter. The letter we have just perused, Your Lordship. Letter addressed to the Director of School Education requesting to consider the Odio clan as the landowners. Your Lordship,
But the respondent number 5 has not been appointed on land ownership basis.
Your Lordship,
Respondent number 5 is not appointed on land ownership basis.
no, Your Lordship. As far as respondent 5 is concerned, the department received 2 applications, Your Lordship, and the department had forwarded the 2 applications. That is the application of the respondent, private respondent, and the petitioners. It was forwarded to the government for approval, and the government, after deliberation, they accorded the approval to the respondent 5. No,
But all right,
yes,
there is one OM of the government
yes,
regarding appointment of grade 3 and grade 4 posts.
Your Lordship,
So there must be an advertisement,
yes,
must be interview.
Your Lordship.
That has not been followed.
No advertisement and no interview was.
Do you have that memorandum with you?
I don't have it on me, Your Lordship.
Okay.
But yes, it does say that advertisement should be given, except on situations where the government faces certain difficulties, they can dispense. But again, we have
here
to
going by
show-
the appointment order, it cannot be said that the government has appointed him on that consideration.
Lordship, that has not, no instruction or I have not received on that line and so on, Lordship. This does not concern us.
My lord, I may be allowed to make a short submission in.
No, whether he has completed. You have completed?
Yes,
Your
Lordship.
part?
As far as the government is concerned,
Okay.
we are saying that
Okay.
someone has already been appointed from their clan,
Mm.
and the petitioner has not established that there was any verbal agreement between the government. So by virtue of this OM, the notification dated 5th March 2018, the petitioner has no locus standi to ask for employment on the basis of land ownership. That is the government's stand.
Yes.
My lord, in respect to the submission made by the learned counsel for the state, I would like to make a short submission. My lord, now at page number 3, the affidavit in opposition filed by the state respondent lordship. In second paragraph, line number 6, lordship. At
Page number?
Page 3, lordship.
Page 3, line number
At
6.
second para,
Yes.
line number 6, lordship. Lordship, the state respondent has admitted that, my lord, I may be allowed to read. That
Yes.
the approach road that leads to the government higher secondary school, Sangro for the east belong to the Otoyo clan and not an individual land. which means they have accepted that the land belongs to the Authorised clan. Now, my lord, coming to the last paragraph, it is clearly mentioned that on further deliberation, it was verified that though none of the family members of the petitioner had availed the benefit of employment under the said establishment, that one Shuri so-and-so belonged to so-and-so clan had been appointed and is presently, however, no record could be traced with regard to the grounds of his employment. Now, Lordship,
Page number? You are referring to page number?
at third para, Lordship.
Same.
Yes, Lordship, same page, third para, Lordship.
Yes.
Yes.
That on further deliberation.
Yes, Lordship. The state respondent has categorically mentioned that though one of the person has availed the benefit, however, no trace could be with regard to the grounds of his employment. Now, Lordship, coming to my reply to the affidavit in opposition filed by the state respondent, Lordship, me kindly allow my reply. To the affidavit in opposition filed by the state, Lordship. At page number 2, Lordship. At para number 2, Lordship. Para 2. Lordship, para 2.
Yes.
Line number 10, Lordship.
Yes.
Yes, Lordship, in line number 10, I may be allowed to read, Lordship. That the petitioner humbly states that at the time of acquiring the land, the state respondent had verbally assured that a grid for house would be provided in lieu of the land. Accordingly, the same had been reflected in the sketch map. That is at annexure 2 of my writ petition, Lordship. On the verbal assurance, the state respondent has also reflected in the sketch map that the largest portion of the land will be provided a quid pro quo, which simply proved that they have assured with the verbal assurance. Now, Lordship, may kindly come to next page, Lordship. Yes. And the second, I may be allowed to read, which simply proved that none of the family members of the clan had availed any employment opportunities on the basis of landowner. That further Shuri, Egrimo parental uncle Shuri Suensu in the grandfather of the petitioner in Shuri Suensu approved the signature. There is the letter dated annexure 6 of the affidavit in opposition. It does not prove that the Shiri Egimu, he was not appointed on the basis of land ownership, Lordship. Now, Lordship, me kindly come to my second paragraph, Lordship. Is Lordship, the state respondent in their affidavit in opposition stated that the existence of a verbal assurance by the department for providing employment to the petitioner on land ownership in lieu of the land donated has not been established. The statement is baseless, wherein the department clearly admitted that the approach road to the government high school Songru Wuka belongs to petitioner's land. As such, the petitioner, being the landowner of the approach road to the government high school, have Lucas standing to claim the employment on the basis of land ownership. Lordship, with regard to the office memorandum, I'd also like to place one office
Yes,
memorandum,
madam.
3rd March 2022.
This is the, that your lordship was asking.
Yes, Lordship.
Yes.
Yes, Lordship, filling up of Group D posts in the department, corrigendum issued. The procedure of filling up grade 4 posts in the government has been laid on void office number so-and-so, dated so-and-so. The letter memorandum lists on the application for recruitment to the post should be called through open advertisement. Number 2, following difficulties expressed by various department
on account of the fact that in many cases, cooperative pools such as Together Mali in Pune are filled by the landowners or on compassionate ground, on locality, the district subdivision or village level. The matter was considered by the cabinet in its meeting held on date Swinso. In order to remove such difficulties, it is hereby directed that the condition of advertisement is dispensed with whichever such difficulties are faced by the department. As long as the fair and transparent eligibility criteria and process is followed in all such cases, approval of the government is obtained. Now, Your Lordship, this OM is very clear, Lordship. However, the appointment made of the respondent number 5, it was neither a landowner nor a landowner, Lordship. Moreover, no sort of interview or advertisement has been made in regard to the appointment of this respondent number 5, Lordship.
So whether the other two office memorandum dated 26/10/2017 and 24/3/2018 are available with you?
I can search it, Lordship. I don't have it on me.
Okay.
Yes.
So this OM is virtually a corrigendum
Yes.
in respect of the earlier OM. Okay. Can you produce these documents on next working day,
Your Lordship. I will-
Thursday?
Thursday.
Okay. But we will close the matter today. Close means close the argument today. We reserve the judgment.
Yes.
Third, Mr.
Pushittam
Learned counsel for the petitioner. Mr.
M. Longcomer.
M. Longkumar, learned government advocate for the state respondent, and Mr. Stephen Yanthan, learned counsel for the respondent number 5. Argument concluded, judgment reserved.
Much appreciated.
Lordship.
From the supplementary cost list for referral to the special mediation drive for admission, item number 47.
May I place your Lordship?
Yes.
Lordship, this matter has been listed for referral before the special mediation.
Okay.
Lordship, the petitioner is not agreeable for mediation. So may I pray that if this matter may be listed in the usual process.
Under which column? It is in admission column or?
Yes, your Lordship.
Admission column.
Yes.
Third, Mr. Your name, please?
Manjong Konyak.
Learned counsel for the petitioner. None appears for the respondent on call. Learned counsel for the petitioner submits that the petitioners are not interested in settling the matter in mediation. Only one petitioner is there, that the petitioner is
Yes,
not
sir.
interested
There's
in
one.
settling the matter in mediation. And as such, the matter may be listed for admission on next date. We are allowed to list the matter on when? When?
Any that your Lordship, as per convening of this honorable court.
Yes, so is that it? The next week,
Lordship, the state is yet to file objections in this matter. So
oh, they have not filed
they have
their,
not filed any objections to them.
okay. Okay, after 2 weeks then? In the
Lordship-
meantime, the state respondents may file their counter affidavit.
Your Lordship, I have a similar prayer for item 43. I think the state council has already adjourned this matter. This is also the same matter, Lordship. Item 43.
Yes, this was adjourned.
Obliged.
But here also the party is not interested to settle the matter in mediation.
Yes, my lord.
43. Itu eke order koi diba. Here also affidavit has not been.
Not
filed.
yet filed.
Okay, same order. Okay.
For hearing, item number 27.
Please, Lordship.
Yes.
Lordship, the matter pertains to the appointment on land ownership basis. But before I come to the annexures, I may be kindly allowed to highlight the background of the case. This case has a checkered history, Lordship. By order dated 5/8/2022, a vacancy of medical attendant, which is a grade 4 post, was created at Kechok Subcenter under Chief Medical Officer Tunsang. So as a landowner, the petitioner applied for the appointment against the said vacancy. And it was processed in the Directorate of Medical Health and Family Welfare. However, then when the file was processing, the file went missing. And after thorough search here and there, the file processing for the appointment against this vacancy was located at Secretariat. Therefore, the petitioner now submitted a representation to withhold the movement of the said file. Later on, with the intervention of the respondent number 2 and 3, the file movement was stopped and I was permitted to reapply the application for the said appointment. Lordship, may kindly come to page annexure G, page 24. This is the application which I was resubmitted and routed through the Chief Medical Officer Tunsang, Lordship. May I read? I'm reading the body of the petitioner, Lordship. This is in pursuance to my representation submitted to the Commission Secretary and Principal Director, Health and Family Welfare in April 2023, Lordship. In this regard, I would like to state that I made a representation to keep the file such and such, and abeyance as my application submitted earlier for appointment was missing in the file. Copy of the representation enclosed. As such, I resubmit my application for appointment against the vacant post of medical attendant lying vacant at Kechok Subcenter. Vice such and such. Lordship, now after this, the letter was now next. Annexure H is the forwarding by the Chief Medical Officer Tunsang. And my application was again forwarded by the respondent number 3 to respondent number 2. And later on, further to my dismay again, the case of the respondent number 4 was approved by the Imbune dated 3/11/2023, subsequently, and by Imbune Order 13/11/2023, the private respondent was appointed without any regular selection process. Lordship, that's my case.
So you have donated land
Lordship,
for that.
constructions of the subcenter under Kechuk subcenter and Kechuk village, Lordship.
Okay. Was there any agreement between you and the state respondent that while providing the land to the state respondent?
Lordship, there was no agreement as such, but that is not disputed by the state also.
Not disputed.
Not disputed, Lordship.
Okay.
It's not disputed that we really donated the land.
Okay. So there was no advertisement.
No advertisement,
interview.
Lordship. No. Even otherwise, no advertisement.
Yes, for the state respondent.
Lordship, as the matter of land ownership has been clearly settled by this notification dated 5th March 2018, Clause 3C of the said notification says that it is also clarified that it is not a policy of the government to provide employment to the landowner in perpetuity. The employment of the landowner, if permitted by a verifiable and valid agreement, is limited to the first person appointed as landowner in government service. So the benefit of employment on land ownership basis can be availed only once. That is the standing policy of the state. Your Lordship. This more particular and specifically, this land was donated by the petitioner's uncle, the father's brother. And on examination, it was found that the father of the petitioner, one Sri Popin Mongko Chang, the father of the petitioner, was appointed on land ownership basis. Your Lordship, I'm reading from paragraph 4 of my affidavit in opposition.
Yes.
Yes, para 6. May I continue, Your Lordship? Yes. The answering deponent humbly submits that the land on which the Kichok subcenter stands was donated by Sri Binyam Chong Chang, the brother of the petitioner's father. It is further respectfully submitted that the claim of the petitioner that no one is appointed from the petitioner's family on the basis of land ownership base is totally misconceived. Mr. Popin Mongko Chang, the father of the petitioner, was appointed on land ownership basis and served as medical attendant under the said establishment. Lordship. The next, Your Lordship. Therefore, the benefit of employment on land ownership basis, as per the notification dated 5th March 2018, Your Lordship, has already been availed by the landowner. Since the father has already availed on land ownership basis, as such, the petitioner herein cannot claim again appointment on land ownership basis, Your Lordship. As far as, yes.
Who is for the private respondent?
She's not present today, Your Lordship. She was present through VC in the morning once, but
Today?
yes, this morning.
Okay.
We didn't mention her.
Then can we take it up on Thursday
Lordship.
as partnered? Because without hearing the other side, it would not be proper to.
Your Lordship. Lordship, may I kindly come to order 24/3/2026 passed by this court. Actually, the defense of the private respondent before is struck off by this court.
Struck off?
Yes, Lordship.
Order dated?
24/3/2026. Para for Lordship. May I read, Lordship?
Yes.
This court depars the respondent number 4 to file any affidavit in opposition and her defense is struck off. This is order
Okay.
dated 24.
Then there is no necessity of adjourning the matter.
Lordship.
Okay. But respondent number 4 was not appointed on land ownership basis also.
No, Your Lordship. This was also based on the applications that they had submitted to the department, and the department had forwarded the applications to the government for approval. And the government had given approval in favor of respondent form. No advertisement was, or interview was conducted, Your Lordship. As such.
Lordship, may I make a brief submission in regards to the submission made by the State Council? Lordship, may I kindly come to my reply to the affidavit in opposition, Annexure L2. Page 6. My reply to the affidavit in opposition. L2, page 6.
Yes.
Lordship, this is the only record available for the appointment of my father, who was not appointed on land ownership basis.
Okay.
It's not. So since I have donated the land, I am entitled to be appointed on land ownership basis because the records clearly shows. May I kindly read, Lordship? Appointed as medical attendant against Kichok F.W. Subsender, White Order, such and such. And nothing is there. So the state respondent cannot claim that they have appointed my father on land ownership basis. No, Lordship.
Okay. Is there any stay order operating in this petition?
No, Lordship.
No.
If I may allow Your Lordship, just to retract on that, there's no agreement between the government and the landowner with regards to giving employment or a contract for that matter, Your Lordship. So without any agreement as such, on that note.
Lordship, may kindly come to, in that regard, Lordship, may kindly come to Annexure A, page 17 of my petition. Okay.
Yes.
Lordship, may I read the relevant para? Clause 3B. If there is a claim for providing employment as a result of oral agreement, the department concerned shall refer the matter to the Deputy Commissioner of the district concerned, who shall examine such claim carefully, including whether any employment or any other facility, including contract or supply order, has been given in the past. Written statements from the witnesses, that is, government officials of the concerned department and the district administration and village functionaries present at the time of such oral agreement, should be taken by the Deputy Commissioner. The recommendation of the Deputy Commissioner should be referred with relevant documents to the Department of Land Revenue for advice and such cases by the department concerned. So, Lordship, it is the duty of the state respondents to refer the matter to the Deputy Commissioner to verify whether the privilege and facilities was given to my father or any of the landowners. But it was not done. Rather, they agreed that the land is donated by us.
Okay. Third, Mr.
H. Makam.
Learned counsel for the petitioner and Mr. Longkuma for the state respondent. Argument concluded, judgment reserved.
Obliged, Your Lordship.
Obliged, Lordship.
Will I resume after 5 minutes?
I take this one. This one here. Government is and LPR short. You're right. Okay.
You can take a picture of this and you can give me in WhatsApp. Then you
No,
don't have
you
to-
wanna, and I understand my knowledge. It's okay, just right. That's better. Item.
First of all, 39,
39.
the government handbook.
And Mr. N.
Mr.
How many weeks? I also don't get, okay, the first two, how many weeks you remember?
No, I don't remember, but I can see.
Okay.
Then number 3.
39, 40.
For same, I know. Number
Item.
3. Item number 3. For the respondent numbers 4, 5, and 6.
Itipak, Mr. Itipak. Mr.
Then 33. On behalf of Chinan Uzunonu, on behalf of Chinan.
Lilim food. Lilim.
L.E.
Limthong. Lilim Thong P Yum Chunga.
P.
Lilim Thong P Yum Chunga. YIMCHUNGER. Okay.
Next 28.
Muachamer, Mr. Muachamer.
So on behalf of Lucino.
No. Muachamer is for respondent 5 and 7. For respondent number 6 is the same person, the P. Lilim Thong Yum Chunga. For Lucino R6 na. Lucino Miss. Fine, Lilim Thong. Miss. On behalf of Miss
Lucino.
Lucino, LHOU.
Okay. Okay. Then number 45. Government handbook.
I am Katie Imchen, Miss
Miss
Petitioner, Katie Imchen.
Petitioner? No, I don't have petitioner.
I am
Mr. A.
Miss, okay, Miss.
Miss A.
Government.
Okay. Then 46, Miss, on behalf of Miss Livika.
Yeah. Viveka by same person, I am.
Same, no? Okay. Then number 31.
Pichano.
Mr.
To show that you know, na?
Mr.
Miss Pichano.
Miss
For Miss Visocre, additional teaching.
Chano for Mr.
For Miss Visocre, for MS Socre. MS V
P.
Socre, SOU.
HR.
HRIE.
Then 36. Government, okay. Pichano.
Yeah. Pichano.
May it please Lordship.
Yes.
To the matter pertains to occupation of the petitioner's land. It is similar to the today's motion item, Lordship.
Yes.
But the district is different, Lordship. In the state of Nagaland, it's under Traisang district, Lordship. And altogether, there are 84 petitioners who are approaching this honorable court for an appropriate direction. Lordship, the facts are a little bulky, but I'll be taking your Lordship only to few relevant documents. 2 documents by the state government and 2 by the central government, Lordship, which covers my case. Before coming to the annexures, Lordship, the short facts is that in the year 1987, Lordship, in the year 1987, the respondent numbers 1 to 4, who are the Assam Rifles, they have
in the year
57, Lordship.
57.
57.
Yes. Okay.
The respondents number 1 to 4, who are the Assam Rifles, also includes the ministry. They have occupied my land, and the total area of land is 289 acres of land. 289 acres of land, and it was occupied in the year 1857. Now, as on today, they are continuing for a period of 69 years. 69 years. Now, from time to time, survey has been conducted by the state government, which was also forwarded to the ministry for consideration. So those facts are admitted, Lordship. And there's also interestingly another fact which is being admitted and which has not been disputed by neither of the respondents is that the land was not acquired in terms of the law. There's an act in the state of Nagaland, the Land Requisition Acquisition Act 1965, where there are clear provisions provided in the act, as well as there is central act, that is Land Acquisition Act of 1894. Provisions are very clear. None of the affidavits filed by the respondents, they have enclosed any of the document to show that the land was acquired in terms of the law. So that is the admitted position as far as all the pleadings are concerned. Now coming to the documents, Lordship. If I may be allowed to take your Lordship to page 47. Page 47. I'll be referring to only few documents which are very relevant. Now, this is a document, this is a notification which was issued by the state government, the Land Revenue Department, who is also one of the parties in this case. This is notification dated 8 June 1987. It was in the year 1987. Now, may I read it, Lordship? In cancellation of this department letter number so-and-so dated so-and-so, the governor of Nagaland is pleased to state that the land required by the central government agencies, very clear, or private agencies for the purpose considered to be in public interest, now the public interest is also used, shall be leased out to those agencies on payment of a premium equivalent to the cost of compensation paid to the landowners. The first criteria is premium equivalent to the land compensation. They have to pay the premium. And the second requirement is and on payment of annual rent. So there are 2. Premium, in other words, it's the land compensation. Once you acquire, you have to pay land compensation. Second is rent. And this second condition is also relevant in this case. Because for the last 69 years, neither they have acquired the land, nor any payment was made. So both are relevant in my case. And the state of Nagaland, they have issued a notification, and it is for compliance of all. All. It can be any central government agencies or any agencies, provided it is occupied or acquired in public interest. Now, continuing this, the period of lease will be decided by the Deputy Commissioner, but shall not exceed 50 years initially. So the concerned Deputy Commissioner has to decide, and the concerned Deputy Commissioner will execute such lease agreement, and the Deputy Commissioner shall also represent the state government while executing the lease agreement. So in the present case, if the respondents more particularly the respondents number 1 to 4, if they have any intention of acquiring or occupying the land, they should enter an agreement with the state government, which is to be represented by the concerned deputy commissioner. And the present case, it is the deputy commissioner of Train-Sang. And there is also a condition specifically says that it has to be for a period of 50 years or not more than 50 years. Now, in my present case, as I have rightly pointed out, 69 years. And in the last 69 years, it's almost 7 decades now, no initiation from the central government to execute such lease agreement. In other words, they are occupying without payment of any rent. Yes. Paragraph 2. May I read it? The agreement for lease shall be executed by the central government agencies or concerned private agencies, as the case may be, with the deputy commissioner of the district where the land has been acquired. So this is what I have just made my submission. The latter shall do as representative of the state government. 2 copies of the agreement so as to execute it above shall be endorsed for record to the government in the Land and Revenue Department, and 1 copy to the Director and Records and Survey, Nagaland, Dimapur. So 2 copies. They should have such record. No, unfortunately, well, this state government, they have filed their affidavit and they have stated that no such record is to be found. In other words, they are yet to execute any such agreement. So it is as good as there is no agreement that has been executed at any relevant point of time. Now coming to page 49. May I take your lordship to page 49. This is an order, a general order for payment of rent issued by the Land Revenue Department. This is dated 29th of August 1989. The governor of Nagaland is pleased to enhance the fee for occupation of land from rupees 60 to rupees 200. Only per acre per annum, with immediate effect, all future renewals should be on this rate. So it was in the year 1989, and this has been renewed from time to time. This document has been enclosed just to show that the state government has a notification or an executive instruction to show that the state government has an intention to give rent, or in other words, the state government will initiate, but there has to be a rate fixed. So this is also one of such rates which has been enhanced from time to time. Now coming to the ministry's office memorandum, page 56. Page 56. This is a guideline issued by the Ministry of Home Affairs, a very exhaustive and a clear office memorandum. It has also referred to some provisions which are relevant under the Land Acquisition Act of 1894. And it is for the entire country. It is dated 15 November 2002. This document is very important, and I'll be referring to this as I proceed with my submission. Subject. May I read it, Your Lordship? Guidelines for land acquisition by Central Police Organization, CPOs. It has come to notice of this ministry that at times CPOs are not submitting proposals for administrative approval and expenditure sanctioned in respect of land acquisition cases.
So whether Assam Rifles are considered as CPO?
Yes, very much, Lordship.
Okay.
Very much, Lordship. There are also communications between the 2 governments, Lordship, central as well as the state. May I continue, Lordship? Proposal for administrative approval and expenditure sanctioned in respect of land acquisition cases where estimates have been sanctioned. This is very important. Estimate comes first, Lordship. And the reason why I point out this, I'll cite it as we proceed, Lordship. And awards made by the state government well in time. The word award is also there. and it's a key word as far as this case is concerned. A word has to be there. One of the reasons it seems to is the non-availability of funds in the relevant financial year. In such cases, at times, organizations suo motu decide to submit the proposals in the next financial year. This is important. Such action on the part of the CPOs has sometimes led to lapse of land acquisition proceedings, thereby leading to initiation of fresh land acquisition proceedings and consequent avoidable extra expenditure as well as time loss. CAG has also pointed out that some of the lapse of the part of the CPOs in this regard. 2, this is a very important, Lordship, paragraph 2. All cases of land acquisition in future should be processed, keeping in view the relevant provisions of Land Acquisition Act 1894 and guidelines prescribed here and now the guidelines. A, approval of key location plan.
No, that's all right. The question is, it is clear that your land has not been acquired by
Yes, Lordship. Yes,
state
Lordship.
respondents.
Now, in that case, if I may be allowed to take your Lordship to clause 5, page 57, this is very important because I'm also seeking for such kind of a direction which is part of the guidelines, Lordship. Paragraph 3, clause 5, the bottom, Lordship. Preparation of estimates. As per the scheme of Land Acquisition Act 1894, the estimate of land proposed to be acquired is made by the collector after issuance of order under section 7. 7 has been decided. Collector to take order of acquisition. Section 7 talks about collector to take order of acquisition. Now, may I continue? The estimate is prepared based on the rates of the land prevailing on the date of notification under section 4 of the Act, and it includes interest on the land value upon the probable date of making the award of land acquisition. So an estimate has to be prepared. Administrative approval and expenditure. In view of past experiences, this is very important. Now it covers my case also, where the requiring bodies, in this case, CPOs, drop the proposal of land acquisition. This is a practical difficulty. After publication of notices under section 4 and 6 of the Act. Now, notice is being published under 4 and 6 as mandated. Now, once the notice is being published, they withdraw the proposal. So, in order to avoid such difficulties, the state governments nowadays don't start a land acquisition proceeding till the requiring bodies place the estimated cost of acquisition with them. In such cases, state authorities or collectors prepare a tentative estimate prior to publication of notice under section 4 of the Act. The RB has to deposit the estimate before the land acquisition proceedings are initiated. And this direction is crystal clear. Before they proceed with the acquisition, an estimate has to be submitted. That estimate amount has to be deposited before the state government, before initiating with the acquisition proceeding. And I'm seeking a similar direction before the Honorable Court. Land has to be acquired, no doubt. Section 4 and 6 has to be fulfilled. But even prior to initiating 4 and 6 of the Act of 1894, the estimated cost has to be deposited before either with the state government or the collector. And this is a guideline issued by the ministry.
No, but the question is whether the present this notification is presently holding the field, because
very much large.
Now the 2013 Act is already there.
Yes, Lordship. I'll even come to that. Why 13 and why 1894 is also relevant in my case, as well as even the State Act of 1865 is also relevant. And a similar situated case, a coordinated bench of this Honorable Court has passed an order discussing about the provisions of all these acts. I'll come to that, Lordship. Now, page 69. This guideline was issued in the year 2002, and now page 69 is pertaining to a communication in the year 2011. Page 69. This was written by the Deputy Commissioner, the collector of the district of Toinsang, Nagaland. Some facts has been highlighted in this communication. May I read some few relevant paragraphs, Lordship? Para 1. That the area of land measuring 289 acres which belongs to C-Cal was proposed by the AR for public purpose somewhere in the year 1857. So this is an official report. The subject land was surveyed jointly and handed over for establishment of 8 Assam Rifles. The record is very clear. Para 3. As the land was purely on temporary measures to maintain law and order situation in the state of Nagaland. As such, at no point of time legal deed of agreement whatsoever, its nature was neither executed before the entrusted parties, nor is in existence with the revenue records of the state government. They have clearly admitted. They have perused the records, so there's no record to show that there was any agreement executed at any relevant point of time. Next, I'll read paragraph 5, if your lordship allows. On being jointly resurveyed, again it was resurveyed again, the land area of land measuring 239.5 acres was found in physical possession with the AR with effect from 1992. I will fairly admit this. My initial, even in my pleadings, I have stated that it's 289 acres of land. Now, after resurveyed, they have submitted a report that it is 239. Instead of 289, it is 239. Physical possession. Physical possession by the ARs. On that, I will also come to some documents, Lordship.
No, is there any dispute in this regard?
There's no dispute, Lordship. There's no dispute.
239.5 acre is the actual land.
Lordship.
Under the physical possession of the respondents.
Yes, Lordship. There's no dispute, Lordship. Now coming to page 76. Page 76. After the Deputy Commissioner has written a letter in the year 2011, nothing was forthcoming, and this is in the year 2018. May I read it, Lordship? Report of the land occupied by the paramilitary forces in the Nagaland from the beginning of 30th of June 2018. I'm directed to refer to the department's letter of even number dated so-and-so, and to state that the report of the land occupied by the paramilitary forces in Nagaland from the beginning of so-and-so has not been furnished from your end. You are therefore requested to submit a report to the government at the earliest for necessary action. So there were some communications made between the respondents. Now coming to a document issued by the respondents, central government, Lordship, page 78. This is just to show that they are also admitting about 289, 78, page 78. This is a document which was issued by the Director General, Assam Rifles. Paragraph 3. Paragraph 3. The same is being sent to MHA. Before that, you are requested to authenticate the details at the earliest. So there's a chart provided, and this chart shows about the areas of land occupied in the state of Nagaland. And they have arranged in district-wise. Now my area of land, Lord, you will find at page number 80. This is pertaining to the Toinsang district. Toinsang district A, Toinsang headquarter. Mine is in the headquarter, which falls under the jurisdiction of Toinsang village, Toinsang headquarter, and this is an area of land is 289.01. And this is a document of the respondents. Respondents 1 to 4. So they have fairly admitted this. Land acquired in the year 1962. That is what the document says.
But according to you, the land is under their physical possession since the year 1957.
57, Lordship.
And according to their document,
Yes.
land was acquired in the year 1962.
Yes, Lordship.
So these are disputed questions of facts.
Lordship. Even otherwise, Lordship,
Mm.
if the state government can bring on record to show that it was either occupied in the year 1957 or 1962, I'll leave it to the state government, Lordship. But my contention and my respectful submission before this Honorable Forest, it was occupied in the year 1957. That is my respectful submission, Lordship. Now the state government, as well as the central government, they have also filed the affidavit and they will also apprise before this on the court as to the contention of the state, Lordship. Now, before coming to that, Lordship, in a document which has been admitted even by the state government is that the central government has raised that an amount of rupees 90,000 was paid way back in the year when they have occupied the land. Now, my respectful submission before the central court, I've also filed my affidavit in reply. I'm denying to that, Lordship. Even assuming but not admitting, Lordship, if the landowners have received such amount amounting to rupees 90,000, it will be at best for temporary occupation. And that has also been clearly stated in the state's affidavit, temporary occupation. And temporary occupation does not amount to acquisition in the eyes of law. Your Lordship knows very well. If there is an acquisition, there should be a notice, which is mandated under the Act of 1894 as well as in the Act of 1965. There should be a notice. I should be given an opportunity to raise objection. And the acquisition proceeding proceeds, Lordship. At the culmination, Lordship, what happens? An award is being issued. They should bring on record all such procedures being adopted from time to time. In none of the affidavits filed by the respondents, with due respect, Lordship, not even a single document to show that my land was acquired at any relevant point of time. My land was acquired in terms of the provision of law. In fact, not even a notice, Lordship. And notice alone does not fulfill the requirement of the Act. It culminates with an award. Now, on that, Lordship, if I may be allowed to place just few judicial pronouncements, and after that, I'll conclude my submission, Lordship, subject to any rebuttal later on, Lordship. Lordship, SSC 2024, Volume 10, Lordship. Lordship, I'll take to page 550. My relevant paragraph starts from para 29, 550. If your Lordship got it.
Yes.
May I read, Lordship? Paragraph 29.
Mm.
The constitutional discourse on compulsory acquisitions has rooted itself within the power of eminent domain. Even within that articulation, the twin conditions of the acquisition being for a public purpose and subjecting the divestiture of the payment of compensation in lieu of acquisition were maintained. Although not explicitly contained in Article 300A of the Constitution, these twin requirements have been read in and inferred as necessary conditions for compulsory deprivation to afford protection to the individuals who are being divested of property. A post-colonial reading of the Constitution cannot limit itself to these components alone. The binary reading of the constitutional right to property must give way to more meaningful redations, where the larger right of property is seen as comprising intersecting sub-rights, each with a distinct character but interconnected to constitute the whole. These sub-rights weave themselves into each other, and as a consequence, state action or the legislation that results in the deprivation of private property must be measured against this constitutional net as a whole and not just one or many of its strengths. 30. What then are these sub-rights or strengths of this Swedish constitutional fabric constituting the right of property? Seven such sub-rights can be identified. This is very important, Lordship, the sub-rights. 1. The duty of the state to inform the person that it intends to acquire this property not fulfilled, Lordship. The right to notice. 2. The second sub-right, the duty of the state to hear objections to the acquisition, the right to be heard, not complied with. 3. The duty of the state to inform the person of its decision to acquire, the right to be reasoned decisioned, even this not complied with. 4. The duty of the state to demonstrate that the acquisition is for public purpose, the duty to acquire only for public purpose. This too has not been fulfilled. 5. The duty of the state to restitute and rehabilitate, the right of restitution or fair compensation. This too has also not been fulfilled. 6. The duty of the state to conduct the process of acquisition efficiently and within prescribed timelines of the proceedings. The right to an efficient and expeditious process, unfortunately not complied with. 7. And the last, the final conclusion of the proceedings leading to vesting, the right of conclusion. None of these sub-rights have been complied with. 31. These 7 rights are foundational components of a law that is tuned with Article 300A, and the absence of one of this or some of them would render the law susceptible to challenge. I do one of this also. The judgment of this court in KT Plantation declares that the law envisaged under Article 300A must be in line with the overarching principles of rule of law and must be just, fair, and reasonable. It is, of course, precedentially sound to describe some of these sub-rights as procedural and nomenclature that often tends to undermine the inherent worth of the safeguards. These 7 sub-rights may be procedures, but they do not constitute the real content of the right of property under Article 300A. Non-compliance of this will amount to violation of the right being without the authority of law. Clearly laid down, and it squarely covers my case, Lordship.
Okay. Next.
Lordship, a judgment of this coordinate bench of this Honorable Court, Lordship. I'll start from paragraph 7, Lordship. My apologies for troubling your Lordship, Lordship. Paragraph 7, Lordship. 635, page 635. Paragraph 7. May I read it, Lordship? First and foremost, it is relevant to take note as to what are the terms of reference. The said terms of reference which were made on so and so has already been noted here and above. Amongst the various terms of reference, one of such terms is realm so and so was whether the landowner village was entitled to enhanced compensation, and if so, on what basis and what are the amounts. The said terms of reference, insofar as the enhanced compensation is in questions, does not limit the determination of compensation to the provisions of the Act of 1965. This is the State Act, or the Land Acquisition Act of 1894. The compensation which is required to be granted on the basis of acquisition has to be just and fair compensation as per the provisions of the prevailing law. Section 11 of the Act of 65 stipulates the manner in which the compensation is to be arrived at. While Section 11(1) stipulates that the market value of the land has to be taken into consideration for a period of 5 years preceding the date of publication of the notice, they are yet to publish notice, Lordship. Under Section 6(1) of the Act of 65, and when the land is acquired under Section 9 of the Act, from the date of passing of the order under Section 9(1) of the said Act, and the amount of compensation payable shall be on the basis of average market value so arrived at. Further to that, it has also been provided that in addition to the market value of the land, the collector shall in every case award a sum of 15% of such market value consideration of the nature of acquisition terms with the second proviso to section 11(1). It is relevant to take note of that second proviso was inserted in the provision of 65 White First Amendment Act of 1969. May I come to paragraph 9, Lord?
Yes.
Accordingly, by virtue of the said incorporation of 11th of Act of 1894, the manner of inquiry and award by the collector stipulated in section 11 of Act of
Oh,
8.
Mr. Zomir, you say
Lordship.
nothing has been done in your case.
Lordship.
So how this decision will help you?
Lordship, in order to show that even both this act are also relevant in my case, as well as even Act of 13, because Act of 13 is also. But if your Lordship also is of your opinion, yes, Lordship. They are yet to initiate any proceedings, Lordship.
Yes.
So my respectful submission before this honorable court is a direction should be issued to the state government to first acquire the land and pay compensation in terms of the relevant provisions of law. But before acquiring, they should come up with an estimate and deposit the estimated cost before they initiate with the notice. And also, Lordship, the second prayer is they have been occupying my land for the last 69 years. They have to pay the rent till such time they initiate this acquisition proceedings. From the day they occupied my land till such time they initiate the proceedings, they have to pay the rent.
No, the question is under which act they will acquire the land now?
1965, Lordship, 1965. Because they have to acquire as on date, Lordship, and 65 is in existence. It is the act which is holding the field at the moment in the state.
Now this 2013 act is holding the field.
Now 13, there's a judicial pronouncement that says that for payment of compensation, whichever act is more beneficial to the petitioner will be applicable for payment of compensation. But for acquisition,
13 is more beneficial.
yes, Lordship, 13 is more beneficial. So 13 will apply in case of compensation, but for acquisition, 65 will apply. Because that is the only act in the state of Nagaland for acquisition of land. And that is very much holding the field at the moment, Lordship. So for payment of compensation, 13 act, because that is more beneficial for me, Lordship. But for acquisition, Act of 65, the state government Act of 65, Lordship.
No. Whether the state government act is presently holding the field.
Exactly. Very much holding the field.
There is central legislation. Central Act, 2013 Act.
It is very much in existence, 1965, Lordship. It's very much in existence.
But on the same subject, can two acts, one of state legislature and the other is of parliament, can exist?
Lordship, this authority which I have just relied upon, which pertains to the state of Nagaland, has clearly discussed. For acquisition, it has to be 1965. And for payment of compensation, and there are also other judicial pronouncements of this honorable court. For compensation, it has to be 13 Act.
Anyway, what is the stand of the state government?
May I please, Lordship?
Yes.
Oh, the Union India. The Union India.
Yes.
Wonderful. Wonderful.
I have nothing much to say in this case. I'm only in occupation of the Authorised land.
Pardon?
I'm in occupation of the Authorised land.
Come to mind this.
Yes.
Yes.
I'm in occupation. I have nothing much to say in this case because I am in occupation of the British land. Time and again, I have written to the government to finalize the land. You can see my representation is with my evident possession. Para 1 Annexure J, Lordship. These are the numbers of representations that I have made to the central state government to finalize the land.
Annexure?
This is Para 1 Annexure J. Sorry, Lordship.
Page 6. Page 6 of my affidavit.
You put a respondent number 1 to
1 to
8.
5. 1 to 4. My affidavit, Lordship. Affidavit in opposition.
Yes. Page number?
Page number 6. Page number 6, J. Lordship.
Okay.
These are the correspondence that I have made with the state government, Lordship. We don't have to control all those documents also, but we have already written to the state government to finalize the matters. So far, the state government has not taken any action. And in the writ petition, Lordship, my friend has already stated that, but in the writ petition, Lordship, page 60, to be, I'll go to the type copy, Lordship, page 67. Page 67 is very clear, Lordship. It's a notification issued by the government of Nagaland and the Revenue Department.
Page number 60?
67. The type copy, yes.
Yes.
This is a notification issued by the government of Nagaland
Nagaland.
Land and Revenue Department.
Mm.
Dated 12 January 2006.
Yes.
Whereas the government of Nagaland is pleased to reiterate the department's earlier notification number so and so in connection with the land acquired by the central government and agencies, why the department's notification of event number so and so when it is already notified that the land acquired by the central government of the Union of India or other parties shall be first acquired by the state government, and the list out to the concerned department of the agency or party subject to the approval of government for 50 years initially. Let me not go through all of this, but this is the position. So now, unless and until the state government detect the issue necessary order, so I have no thing to say, Lordship. But it is stated that I am in occupation of the petitions.
Okay.
Otherwise, it is the state government, they should acquire, they should survey and direct the central government to make a list or in whatever conditions the matter land is to be occupied by the central government. That is all, Lordship.
Okay.
May I please, Your Lordship? My Lord, Your Lordship may kindly see the affidavit filed by respondent number 7.
Yes.
Respondent number 7, my Lord. Your Lordship may kindly see para 4. Kindly allow me to read para 4, 5.
Okay.
Yes. May I read, man? That with regard to the statement made in para 7 of the writ petition, the answering deponent humbly begs to state that for the purpose of maintaining law and order situation in Nagaland, it was mutually agreed between the parties that the Assam Rifles will use the land of the petitioners for a short period of time for which an amount of rupees 90,000 was paid as temporary occupation fee from the state fund by the then NIFA government. It is further stated that as per the records of the district administration and the land revenue department, a survey was conducted during 2013 to 2014, which reflects that only 239.5 acres of land forms part of the master plan and is currently under the occupation of Assam Rifles. It is also pertinent to mention herein that there are no written records available to prove that the land occupied by the Assam Rifle is lawfully acquired and the continued possession of the land by the Assam Rifle is illegal. As such, in the absence of a valid lease or renewal, the occupation cannot be treated as lawful occupation without legal authority amounts to unauthorized occupation of the Assam Rifles. That with regard to the statements made in para 8, 9, 10, 11, and 12 of the writ petition, the answering deponent pertinent to state that in the year 1957, the Assam Rifles occupied the land of the petitioners on payment of rupees 90,000 as temporary occupation fee. The said amount was paid from the state fund and not from the central fund. Furthermore, it is apparent from the SGO civil Dunsang letter dated 25/4/2012 that 239.5 acres of land was considered to have been released out to the Assam Rifles from 1957 for a period of 50 years, subject to renewal as clarified by the Deputy Commissioner Dunsang District. Thus, the continued occupation beyond the lapse lease period is subject to renewable and required lawful authorization. Your Lordship may kindly see the Annexer A, Your Lord. Your Lordship, page number 6, Annexer A.
Yes.
Yeah, this is the letter communicated to the Commandant 8 Assam Rifle Dunsang, my lord. May I read? These do the Commandant 8 AR Dunsang. List there is a subject. So further to our reply, our letter number so dated 27 August 1996. I am to clarify the following. Number one, only 239.9 acres of land is under actual occupation by the 8th Assam Rifle at Tunsang as per the latest survey conducted in 1992. 2. The compensation of rupees 90,000 was paid to the landowner from state fund, the then erstwhile NI fund, for 239.5 acres of land as now found after re-survey and not from central government. Therefore, the compensation paid by the state government is now required to be recompensated to state fund before land deed is processed for signature. My lord, by this letter, it is clear that only 90,000 was paid from the state fund during the NIFA, my lord. And as per the para 2, it says that 90,000 will be recompensated by the central government to the state government. So
No, that is not the subject matter of this
yes,
petition.
my lord, that is
that is between you and him.
Yes, and my lord, your lordship may kindly see page number 8, Annex B. Page number 8. May I read, my lord?
Yes.
So and so, sir, I am directed to refer to the subject cited and also invite to above reference for favor of careful perusal before arriving at logical conclusion on the important issue. It is wished to bring to your notice for few of the facts which are as follows. Number one, that the land holding system in the state of Nagaland is entirely different from the rest of the country. Two, that the Bengal Eastern Frontier Regulation 1873 together with the Assam Land Revenue Regulation 1886 have clearly amplified protections of the tribal of Nagaland in matter of settlement and transaction of land. 3. That even according to Article 371 Clause A of the Indian Constitution, no act of parliament in matter of land and resources shall apply to the state of Nagaland unless the Legislative Assembly of Nagaland by resolution so decide. 4. That the various land law policies are being ordered by the Governor of Nagaland and notified from time to time in accordance with the provision under the Constitution of India. A copy of a recent notification dated 21 February 2025 to 225 is in clause 4 reference. That there are a number of similar regulations, orders, notification, memorandum, circulars, etc. issued by the state government in view of a particular land holding system in Nagaland, which are protective provisions in nature and made their rules, regulation, instruction, etc. from time to time. The district administration is made mandatory to enforce those orders in the state. Now, therefore, it is intimated once again the state government of Nagaland has its own land and revenue rules
with specific protection by the Constitution of India. Under this rule, land for public purpose can be leased out initially for 50 years, and there is no provision for acquiring land on permanent basis by outsiders or central government agency. 7. It is self-explanatory that the land has neither been legally acquired under the Land Acquisition Act 1894 and Nagaland Land Requisition and Acquisition Act 1965, nor the state as well as the some rival has record thereof. The land, if so acquired as claimed by the AR authority, then it is requested to place on record the following documents. Clause A, publication made under Section 4 of Land Acquisition Act 1894, declaration made under Section 6 of Land Acquisition Act 1894, notification dated under Section 9 of Land Acquisition Act 1894, award in accordance with principles set out in Section 11 of the Land Acquisition Act 1894. The subject land is considered to have leased out for a period of 50 years, effective from 1957. And the occupation by heir is an admitted fact. The period had been expired and ownership of land is returned to the government of Nagaland unconditionally. The state government also acknowledged payment of 90,000 only as compensation for 50 years. The Assam Rebel Authority not initiating for renewable extension as recorded by law of the land signifies that the subject is no longer recorded by it. The state of Nagaland requests to pay a sum of 17 crore 5,25,300 only. In receipt of assurance, government will publish necessary notification to start process of leasing of land at Tunsang for another 49 years in favor of the President of India. In view of the above, it is requested to initiate payment process to avoid legal hassle and the genuine landowners are adequately compensated. My lord, this letter was issued by the Esther Civil Tunsang. And my lord, it clearly says that there is no record to show that the land has been acquired. Yes, it is admitted that land has not been acquired. And my lord, by para 9, it clearly says that letter has been written to the Union of India to process for payment of compensation rates. And para 8 it clearly says so. But so my lord, now the Union of India has also submitted that they have submitted multiple communication letter to the state government. However, no action has been taken on the part of the state government. So my lord, in this regard, my lord, since there is no acquisition, my lord, acquisition process has not been done, my lord. So direction may be issued for the interest of justice.
So we may allow the pairs made in this petition. Okay. We'll pass the order then.
Yes, my lord. Because of the matter, because it is a fact that I am giving land. It is a fact that it is the state government that should list out the land. As per the
But his contention is that you have to make payment.
Lordship, unless there is an assessment or under the land revenue act or whichever act.
Yes.
So
Yes.
how many amount of compensation should I pay?
Yes.
So unless there is a
No, in this letter, which he has read out.
yes.
It is 17 crore.
Yes. That was the assessment made by the state government.
That was in the year 2012. So if a direction can be issued, this is the estimate which I was referring to in the guideline issued by the ministry. So an estimate has to be first submitted before they initiate the notice or the acquisition proceedings. So it was assessed in the year 2012. So now 14 years has passed. So if a fresh direction can be issued so that the state government comes up with an assessment, an estimate submitted to the central government to deposit that amount before initiating with the acquisition process.
Heard Mr. Mauzamir, learned counsel for the petitioner. Mr. Yangarati, learned CGC, and Mr. learned government advocate for the state respondent. Argument concluded. Order reserved. We'll pass the order shortly.
Macam-macam tadi.
supplementary cause list for hearing item number 34.
Please, Lordship.
Yes, he was supposed to produce that.
Yeah,
OA.
yes, ma'am.
Yeah. Okay, we will pass the order.
Yes, ma'am.
Please, Your Lordship.
Yes,
Lordship, kindly allow me to place one citation.
okay,
2013 for ACC
yes,
465,
yes.
para 9, 10, and 11, Lordship.
This is in connection with?
Your Lordship, if the person claiming relief is not eligible as per the requirement, then he cannot be said to be an aggrieved person and has no legal standing, Lordship. In
No,
support to my
whether he
petition.
does not possess the requisite qualification.
Pardon, Lordship.
Whether the other side has not possessed the
Yes,
requisite qualification.
Lordship, they are not the landowner, and also they are. Lordship, my submission is that the petitioner is not a landowner, and on what basis they are claiming the appointment on the basis of land ownership, and also petitioner is claiming her rights on the
No,
basis
may not
of
be.
the-
Otherwise, also he has the qualification to be appointed in that post.
Lordship,
Yes, my lord, that is what I've already stated in my paragraph also. Even after submission of my documents and then even after the application, I was not called in for any sort of for conducting the interview.
Okay. Okay. So what is the minimum qualification for being appointed as a grade 4 staff?
Lordship, in this case, the question of locus standi that the private respondent is questioning is, even while approaching the state authorities, he approached in the capacity of a landowner when he is not. And their family member also, regardless of whether they are actual landowners or not, they have received appointment. So on the basis of the claim of land ownership, whether he had the right to approach that or not, that is the issue of locus standi. If not, when it goes to the question of qualification, it's a grade 4 post, Your Lordship. So, my lord, as far as the qualification is concerned, we're not raising any issue on that. But when he claimed as a landowner and he's approaching this own court to claim that he deserves appointment on the basis of land ownership, whether he has the locus standi to have approached this own court or not, that is the issue, my lord. If not, beyond that, we have no issue.
No, that's all right.
My lord.
But you are also not appointed on land ownership basis.
Yes, Your Lordship. We were not.
So when OM is holding the field that there must be advertisement, must be interview for filling up the post
My lord, and
in respect of
OM,
public
I
employment.
believe my learned friend for the government council has already produced where, in order to remove difficulties, the interview can be conducted without the
Whether any file has been moved to the government?
My lord.
Whether in respect of you, any file has been moved to the government?
Yes, Your Lordship. In fact, there was file was moved to the government approved.
No.
Yes, Your Lordship.
In respect of removing the difficulties?
Your Lordship, that I am not aware.
Not aware.
No, madam.
Okay. Heard, Mr. Learned counsel for the petition. And Mr. Respondent number 1 to 4.
Yes,
And Madam for the respondent number 5. Argument concluded, judgment reserved.
Much obliged.
Unlisted motion. Item 50.
May it please your lordship. My lord, here, my clients, the petitioners, all the three of them, except for the petitioner number 3, they have served for 30 years, and the petitioner number 3 also running 30 years, almost 30 years. Now, my lord, subsequent to the judgment and order passed by this honorable court, which has got nothing to do with the petitioners, my lord, their regularization also, petitioner number 1 and 2, they have been regularized in the last 12 years. Petitioner number 3 also has been regularized, in the last 10 years. Now the regularization has been cancelled and revoked on a flimsy claim that they had superseded some of the employees in the work charge seniority. My lord, here they are grateful employees. They have no idea on how the seniority has been maintained. They have no bargaining power, no authority. And my lord, by the
No, maybe, but you were admitting that it was contrary to the OM at that time holding the field.
No, my lord, we are not the only ones. This is the action of the state respondents. They are the ones who have gone against their own action. We have not contributed in any manner because
May not be. You may not contribute to it, but the fact remains that at that point of time, one office memorandum was holding the field, and that was ignored while promoting you, while regularizing your service.
Your lordship.
Right?
Your lordship, yes, that is an admitted fact as far as the OM is concerned. But my lord will kindly appreciate this. It has been many years now. They have been regularized for so many years now.
Maybe, but the years of regularization has nothing to do here if your regularization is illegal.
My lord, whether it will be illegal or not is also another aspect of the matter because we are not the only ones who are regularized.
There is a finding in the MPUN orders that yes, OM dated 22nd of September 2004.
Yes, your lordship, which I have annexed at page 60. More particularly the Roman 4. But my lord, here my lord will kindly appreciate this. If my lord may kindly allow me. My lord, here, how is the seniority of the work charge employees being maintained, your lordship? Maybe in the last few years it has been maintained, but we may be under the executive engineer office establishment Mugukru, but we are, 2 of us, petition number 1 and 2, we have always been posted at Zinemoto. So how will we know that we have superseded anyone? There is no contribution at all on the part of the petitioners, your lordship. So on the flimsy ground of the state respondents, especially the 2 petitions, the writ petition and the writ appeal, my lord, there has not been a whisper in the orders of this honorable court for the civil bench and division bench.
Maybe, but whether those judgments are not right in rem. Could you follow?
My lord, as far as the petitioners are concerned, now they are in the fat end of their service career.
No, that's all right.
After serving for 30 years, if their regularization is all of a sudden revoked now, there are hundreds of the other employees also in the same category. So, my lord, why only pick and choose the 3 of us for a regularization to be revoked? And in any case, the 2015 OM also, the moment we reach 30 years, we're supposed to receive the benefit of regularization. So, my lord, after completing 30 years, especially petitioner number 1 and 2, and petitioner number 3 will complete 30 years in November, your lordship. So, where is the logic of removing us, revoking or cancelling our regularization now, after we have completed 30 years or almost about to complete 30 years of a service? Respectfully, your lordship, as far as I am concerned, I do not find any logic on how the state as a model employer, which has been emphasized time and again by this honorable court
Maybe.
as well as the apex court.
They are also supposed to protect the interests of those employees who were superseded by you.
No, my lord, but my lord will kindly appreciate this. In any case, we have now completed 30 years, petitioner number 1 and 2. Petitioner number 3 will complete 30 years in November. So in any case, at this juncture, we would have been regularized in service. Even if our regularization is not cancelled or revoked, we would have been regularized by now. So at this juncture, at the fact end of our service career, to now revoke and cancel our regularization, which took place 12 years back and 10 years back. Lordship,
Yes. So otherwise also they would have been regularized in the meantime. Had they not been regularized in the year 2012,
12 and 16, Your Lordship.
12 and 16.
My lord, at this stage, let notice be soon to obtain instruction.
Mr. Seki, you see, here notice was also issued to you before cancellation of the regularization order.
Yes, Your Lordship. And we have replied to that, but
At best, you could have approached this court at that point of time.
in fact, I have also,
Here, now the order has been passed by the government. That too on 6th of August.
Your Lordship, it was handed over to us only yesterday. And the moment they came, I was also, as a counsel, my lord, I was also scolding them. What were you doing? But these are grateful employees, my lord, sweepers, with very less education. So, my lord, if at all this order is enforced, then, my lord, they have received the full pay, regular pay for the month of July. But if this is enforced by this month, then by next month they will be getting fixed pay again, my lord, back to a work charge employee.
Yes.
That's the urgency why I had to request your lordship to kindly ensure that this order is not
No,
enforced upon them.
Mr. Seki, you see, you have to demonstrate prima facie case in your favor to grant any stay in the impugned orders. Firstly, you say there is office memorandum of 2004.
That
In
is a-
contravention to that office memorandum, your service has been regularized. Secondly, you have been given the notice before cancellation of your regularization.
Well,
You have not approached this court at that point of time.
Lordship.
Thereafter, on 6th of August, this order was passed. And today is 25th. Today is 25th of August.
Well,
Hmm. So you can obtain instruction. Had they not been regularized in the year 2012 and 16, then when their regularization becomes due, in which year? As per the earlier this
My lord, there is one office memorandum, that is 7/3/2015.
Yes.
Says that those who have completed 30 years and enjoying skill of their case will be considered for regularization. So if the petitioner is eligible under that point, then after completion of 30 years, their case will be considered for regularization.
no, here you say two of the petitioners have already completed 30 years.
Yes.
So they are entitled to regularization.
Yes.
And when their regularization becomes due, can you obtain that gradation list?
My lord, now as per the record, it says that reward order has been issued on 6th August.
That's all right.
So my lord, that process may not done, my lord.
Mhm.
Because since they were already regularized. So under that poem, their case may have not
Yes.
processed for regularization.
No, not process
they are-
for
if they are not
regularization,
regularized.
that's all right.
Yes,
Now, since they have been reverted back to their original position,
yes.
Now they are entitled to be regularized as per that office
Yes.
memorandum of 2015. So when their regularization becomes due, can you obtain instruction on that point as per that way?
Yes, my lord, I can do that.
No, two are entitled. That's all right. The third one,
Yes, those who are in that.
yes.
My lord, can we take up on Friday if interim cannot be considered by the lordship then, because in any case, they would have been regularized in service
Yes.
at this point of time now. So, even as a council, I feel sorry for this, the lowest employees.
That's all right, but what to do?
If my learned friend can bring some instruction, then can we take it up on Friday, my lord?
Yes, we can.
Not Friday, next week, my lord. Friday or Friday, I have to go out for my personal work. I have some engagement.
Is my lord sitting next
Monday,
week?
Monday, my lord.
Yes.
Can we take it up on Monday then, my lord?
Okay, no problem.
My lord, petitioner was appointed in the year 1996.
Yes.
Then, in the 2026, the petitioner will complete 30 years.
30 years.
And petition number 2, 30 years.
Petitioner number 1 has completed 30 years, 3rd July 1996. Petitioner number 2, 4th July 1996, already 30 years. Petitioner number 3, 15th November. So by November, we should be completing 30 years.
They are otherwise also entitled to
Yes.
be regularized.
Yes, my lord. If they have completed 30 years, the case will be considered.
Then let us state their case at least. Let there be stay of the petitioner number 1 and 2.
I'll leave it to you, lordship.
The third one, okay. We'll see after production of the
instruction.
Yes. Heard Mr. Second, learned counsel for the petitioner, and Mr. Swinson, learned government advocate for the state respondent. Three petitioners, namely Srimati Inahole Sisi, Srimati Putuli, and Srimati Semi Khayam. Khyam. Approach this court by filing the present petition under Article 226 for washing and setting aside the office order dated 16th August 2026 issued by the 6th of August issued by the respondent number 2.
Yes.
Here also you have not challenged the notification notice issued before cancellation of the order.
Notification, my lord. We have
No,
not
not
changed.
notification. No, no.
In any case,
That notice issued earlier to you.
notice we have not, but the final order we have challenged, my lord.
Issued by the respondent number 2. And also direct the state respondents to restore the position of the petitioners as a regular employee. Mr. Second, learned counsel for the petitioner submits that petitioner number 1 was appointed as works as sweeper by office order dated ES/A/1 Roman 1 WC/ES/T-2 95-96/45-41 dated 3rd of July 1996 and posted under SDO PWD office Junabuto. And her service was regularized by office order dated 17 August 2012. This memo number is there. You can take help of this. And posted under the same establishment. Similarly, petitioner number 2 was appointed as works sweeper by office order dated. Memo number is there, dated Kohima, 4th of July 1996, and posted under SDO PWD office, Zunavoto. And she has changed her name from Tosili to Putuli.
My lord.
And accordingly executed an affidavit to that effect with effect from 30th August 2000, and her service was regularized by office order dated memo number is there, dated Kohima 24th May 2016, and posted under the same establishment. And the petitioner number 3 was appointed as works sweeper by office order dated 15th of November 1996, and posted under SDO PWD office, Konoku. And her service was regularized by office order dated 12th of December 2012, and posted under the establishment of Executive Engineer PWD, which will be at Ace Bukoksang Division. Mr. Seki further submits that in view of the judgment and order dated 26/4/2022, in WPC number 229 of 2021, and also the judgment and order dated 7/11/2025 in readable number 16 of 2023. The state respondent had issued so-called notice on 23rd of June 2026 to the petitioners for cancellation of their regularization on the allegation that they have superseded their seniors in regularization in violation to the office memorandum number AR-3/GEN-67/2001 PT, written bracket PT, dated 22nd of September 2004. And thereafter, their regularization orders were cancelled and they are reverted to their original position as works as employee by order dated 6th of August 2026. Mr. Seki further submits that petitioner number 1 and 2 have already completed 30 years of service. And as such, they are entitled to be regularized as per office memorandum dated
17/3/2015.
17/3 of 2015. And that they have nothing to do with their regularization of service by superseding their seniors as their grade 4 employee and posted in Zunavoto. Posted in Zunavoto. And as such, the impugned orders, according to Mr. Seki, are illegal and arbitrary, and therefore he is contended to interfere with the same. And also, Mr. Seki submits that till disposal of this petition, the interim relief may be granted by staying operation of the impugned order dated 6th of August 2026. The learned government advocate for the state respondent has, however, submits that at this stage only notice may be issued and he may be allowed some time to obtain instruction. Taking note of the submission of learned counsel for both the parties, it is provided that notice be issued to the respondents returnable on Monday.
4th September, by not Thursday. Tomorrow is holiday and the after tomorrow is Friday.
4th September.
Yes, 4th September.
Holiday.
However, no formal notice is required to be issued since he received notice on behalf of all the respondents. However, extra requisite copy of the petition be furnished to him during the course of the day. And further, considering the fact that
Not for third, something.
third,
Fourth is holiday.
further, considering the fact that petitioner number 1 and 2 have already completed 30 years of service. And also in view of the office memorandum dated
2015.
15, this court is of the view that a prima facie case is made out for granting stay of the impugned orders dated so and so, so far the petitioner number 1 and 2 are concerned. And accordingly, the impugned order dated so and so concerning the petitioner number 1 and 2 stands state till 3rd of September. And the pair in respect of the petitioner number 3 will be considered on production of instruction by the learned state council before this court on that day.
Under specific direction may be given the to furnish the instruction.
Okay. The learned government advocate for the state respondent shall obtain instruction as to the due date of their regularization of service as per when dated. No, that is in respect of number 3 is not, she is not entitled to that benefit.
But in any case, my lord, even if it is not a completion of exact 30 years, my lord, even in the other writ petition which was referred by the state authorities, the person served for 29 years and few months, and this honorable court directed that she should also be regularized.
Okay.
Yes, and the state went on appeal, but the appeal was dismissed.
Okay, better you produce the relevant file before this court on that day. The learned government advocate for the state respondent shall produce the relevant file along with the gradation list before this court on 3rd of September.
Obliged.
Any-
Much obliged.